Hi, a great big welcome to everyone who is visiting us here in our office, as well as all the listeners online. There's quite a few of you. Um, to get things started, I wish everyone a happy International Women's Day. For the most important things first, and then a quick intro to who we have here today speaking to you guys. First of all, I am attorney at law Rauno Kinkar. I am a partner here in law firm LEXTAL. I'm also head of the IT/IP Web3 team here. Been dealing with crypto stuff, licensing, and contractual matters for 8 years now, ever since we applied for the first crypto license in Estonia way back in 2000 something. Also with me are two members of the LEXTAL team. I'll let them introduce themselves.
Everybody, my name is Henri Ratnik. I'm an attorney at law here at LEXTAL. Professionally speaking, I specialize on the fintech law and have been doing so for the past 5 years. And pretty much similar stuff as Rauno, so virtual currency licenses, payment services, securities, and so on.
And hello from me as well. My name is Dan-Erik Roosve. I'm an attorney here at LEXTAL. I've been here for 2 years now, and I'm also part of Henri and Rauno's team, which is the IT, IP, and Web3 team. So as the name implies, I also specialize in IT, IP, Web3, which includes AML compliance.
So, and the final guest, the guest of honor, you might say, is Toomas Auväärt. He is from the Ministry of Finance, and he will give a quick introduction about himself also.
Yes, hello everybody. It's great to be part of this seminar today. Unfortunately, I cannot be in Tallinn today to show my physical presence. For this moment, I am in south of Estonia, actually pretty close to Russian border, and I hope this doesn't cause any weird vibrations during my presentation. But to be more serious, my official position in Ministry of Finance is a Deputy Head of Financial Services Policy Department. And later on today, I'm going to speak about what are our plans in respect of implementation MiCA in Estonia.
Thank you, Toomas. A little bit more about intro to get things started. So, LEXTAL, what is it and why are we talking to you guys about MiCA and crypto today? LEXTAL in general is a full-service law firm with offices in Tallinn, Riga, and Vilnius, over 100 people total, helping clients in all imaginable legal fields, including crypto. Crypto has been quite a substantial part of our business for a few years now. Another thing regarding today's seminar, if anybody has any questions, then you can see on screen now, regarding the two presentations, there is a button, Q&A. If you press on it, it will show you a text box into which you can write your questions and share them. If you click on some of the questions, you can also like them. So the questions that get more likes will be higher up in the order and will have a higher chance of getting answered. The questions that we don't make it to in this seminar, if they're left unanswered, we'll do our best to come back to later and maybe send an email to everyone clarifying some finer details. But that, I think, wraps up the general intro part, and we can get down to business. what will be the business of the day? First of all, introduction, that is done. The second part will be key legal aspects of the new regulation. This will be presented by me, Henri, and Dan. This is the substantive part of the MiCA regulation. What does it actually regulate and how? That will include definitions and new types of crypto assets. I'll be going through that. New license and requirements. That will be talked about by Dan, and new rules for ICOs is covered by Henri. And the third part will be talking about the actual adaptation of MiCA into Estonia, and that is the reason why we have Thomas here in this seminar, because he's the person who is going to be doing that in real life through the ministry, and he will give an overview on that. And finally, we'll talk a little bit about random subjects that may have popped up during the seminar. We'll see where the discussion takes us. So, without any further ado, the first matter. How did we get here? I wanted to give just a brief overview of the history of where we started from in terms of crypto regulation and where we have ended up at. And ended up at is, I think, a correct term, because MiCA seems to be the final form of the regulation that we're going to get, at least for quite a while. So we started, let's say, phase one. That lasted roughly until 2017, and it is applicable also on a global scale, but more specifically I'm talking about Estonia, because Estonia has been ahead of the regulatory curve for quite a while, so Estonia is a good example. Until 2017, the regulator more or less had the understanding that crypto is not important. It's something for nerdy developers to do in their spare time and not really requiring a lot of regulation, which at the time, maybe not quite until 2017, but at one point was true. So not really regulated, or was regulated very lightly. Then was the second phase, which lasted until 2020 roughly, which came about because regulators all across the world started to understand that crypto is, or they thought at the time, that crypto is a cash analog. People would have crypto wallets, they would hold them themselves, they would have custody over them, and they would do transactions with crypto themselves. They don't need anybody's help, they are independently doing all of this stuff. Considering that people were handling their money themselves, then quite minimal regulation was reasonable. But then, at one point, they, let's say, discovered, or also the market evolved into understanding that crypto is not always held by the people using it. It's in fact held by exchanges and cold wallets, sometimes even not having unique wallets for all of their users, etc., etc. So the understanding became more like, okay, people might, for security considerations, give away their crypto and give away their keys, so there's a smaller chance of getting hacked. But still, people are using crypto themselves, they can make transactions, there's no money remittance, so to say, in regards to crypto. So still, the regulations became more strict. You get share capital requirements, 12,000 euros in Estonia, etc. But still quite easy to get the license and to keep the license. And then finally, let's say phase 4 is what gave grounds to the current Estonian legislation and also MiCA, in my view, is the understanding that the great majority of crypto business is entirely centralized, meaning that users, common users, would not actually have any control of their keys or of their crypto. Essentially, most large exchanges which are doing the, let's say, the bigger share of the market cap are holding all of the assets and are acting very much similarly to payment service providers. And the regulator finally understood this, and the approach was logically that we're going to regulate crypto service providers in a manner that is analogous to payment service providers, because that's essentially what they are. So this is how we got here. It's been a rather painful journey for many of our clients. As you can see, every couple of years you get completely new regulation changing everything. Coming with that is a lot of expense, both from the legal side as well as actually changing your business model to comply with the new regulations, own funds requirements, you know it all. But the fact of the matter is that we're here now and have to deal with it. So, MiCA is coming. What is it? And why are we talking about it? It's a regulation, meaning that it's directly applicable in all of the EU, once it's adopted, of course. There will be no internal regulations specifically dealing with the matters dealt with in MiCA. There's no need. It's basically the same as GDPR, but for crypto. And what is it? It's intended to uniform the crypto regulation in the EU. So everybody in the EU understands what crypto assets are, and they understand it the same way. Also, there will be unified licensing regimes, passporting, etc. But we'll get to all of that in due course, and we'll talk about it. Passportable. This has been a huge issue. Obviously, a lot of people, more in the past, but a lot of people have the Estonian license, which legally speaking doesn't have any relevance or meaning outside of Estonia. It's not passportable. You can't actually provide virtual currency services under an Estonian license in Poland or Germany or whatever. Once MiCA hits, that will all change. If you do get a MiCA license in any EU jurisdiction, you can passport it to any other EU country, just as you could a payment service provider license. Cross-border crypto service provision made easy or possible. That's the same point, essentially. Right now, people are providing services cross-border under a single Estonian license. For instance, if you take the Estonian license as an example, and the argument is that our place of business is in Estonia and we're actually just passively bringing in customers from other jurisdictions. But that's let's say, a weird argument to make in a lot of contexts, and usually might not necessarily be entirely true. So after MiCA, that's not going to be an issue anymore. If you have a MiCA license, you're good to go across the EU. Now, it will be most likely published in May 2023, so in a couple of months, but Toomas will go over the plan for publishing and adoption and all of that later on. So we'll get into detail about that afterwards. So, MiCA. It's the GDPR for crypto.
One side note from me as well. Yeah. I would like to say that for the reasons that Rauno outlined, actually, in my opinion, the new regulation is a positive thing, because it, first of all, it creates a transparent environment, because as Rauno also mentioned, the law in Estonia has been changing all the time. 6 months has passed, the law has again changed. And a few people, if any, know how to interpret it. So having the MiCA is a good from the transparency situation, but also it's good because this is a EU-wide legislation, which means that it's possible to do business legally and clearly cross-border, and having like a more transparent regulation. So. But we will get into the details soon.
Yeah, I couldn't agree more with what Henri said. It is a strange situation right now where a lot of our clients also would have licenses in different jurisdictions, and it's a hassle, and it's a lot of administrative and also monetary overhead to keep those licenses up to date, etc., etc. So it should be easier in that sense. I'm sure Thomas, when he gets to his presentation, will have some thoughts on whether or not it actually will be easier or it will be much harder, but we can get to that later.
One more point is that the license application may not be easier, but once you get it, then it's done, and most probably it is done for a few years. So there is
Few years.
at least this is something that we can hope for, because when we have this EU-wide regulation, the possibility that it would be changed so often as the Estonian law has been, I think the chances are not slim to none, but the chances are fewer than when compared to Estonian legislation.
Yeah, definitely. Changes will just by default take a lot longer in the EU anyway. So, what does it regulate, and what doesn't it regulate? The simple answer to that question is all crypto assets that aren't securities or some other type of financial instruments regulated as financial services. If it is a crypto asset, it's regulated by MiCA, most likely. There are some exceptions, but that is the key takeaway from this, which is very different from the Estonian regulation, because the Estonian regulation deals very specifically with virtual currencies, meaning payment tokens. So what are crypto assets? Digital representations of a value or a right which may be transferred and stored electronically using distributed ledger technology or similar technology, including utility tokens. That pretty much means every single token made under a blockchain or built onto blockchain technology that is transferable, and that's it. Transferability, main question. E-money tokens. Now, e-money is very specifically regulated in the EU already, but the MiCA brings in another classification of tokens, which are e-money tokens, which are, as we understand them, stable coins, or at least fiat-backed stable coins like USDT and USDC, which is a means of exchange or a means of payment, which is specifically tied to some fiat currency. A new class, asset reference tokens, are essentially tokens the value of which is tied specifically to some sort of asset that is not necessarily fiat money. So you could have gold tokens, you could have iron ore tokens, or you could have tokens the value of which derives from crypto assets pooled together. So very similar to derivatives, or pretty much are derivatives in this context of security regulation. So that is what MiCA regulates. But what is left out? Security tokens are not regulated. So if you have a token that is already regulated by EU legislation regarding financial services, then MiCA is not relevant, because those tokens are sufficiently regulated under, for instance, MiFID II. Fairly understandable. Another key element to keep in mind is that if a token is not transferable, if it's tied to a single user, it is not regulated by MiCA. So if you have, let's say, an in-game currency that is tied to a personalized account, then such tokens would not be considered in the scope of MiCA. Now, the final interesting exemption of what is left out of MiCA is quite a controversial one, or one that is that's raised a lot of questions, to say the least. It's NFTs. So MiCA and its preamble says, in no unclear terms, that MiCA should not apply to crypto assets that are unique and not fungible, so non-fungible tokens, NFTs, including digital art and collectibles. But the interesting part here is that it says whose value is attributable to each crypto asset's unique characteristics and the utility it gives to the token holder. And then MiCA says that if you mint NFTs in large series or collections, then that would actually, under MiCA, be an indicator of the fact that those tokens actually are fungible. So essentially what MiCA is saying is that if you make a drop of 10,000 monkey pictures that are all very much similar with just slight variations, then they're not NFTs. Then they're just, they're fungible, essentially, because they're not, basically what they're saying is that it doesn't matter which one you have. They're all the same for all intents and purposes. The fact that you change the color of the hat on one NFT doesn't really matter to the buyer. The buyer would just buy it for the picture. So that is what is out. I'm sure that this NFT part will create quite a lot of arguments of how large does a series need to be, what is considered a collection, and whether or not it really does take away the fungibility of it or add fungibility to it. But in general, NFTs out, but usually in.
In my opinion, I think the NFTs were more or less kept in because the regulator is looking at the reason why people are buying them.
Yeah.
They are buying them for investment purposes, so they want to speculate, and like this is one of the reasons why Bitcoin, like in the olden days, the take was that Bitcoin is not a security, and it still is. But the regulators have been philosophical about the question whether they should be securities because people are buying Bitcoin for investing purposes, to speculate them in the markets, because people are not buying Bitcoin to pay with Bitcoin at a store to buy pizza, for example. So I think this may be one of the reasons why the NFTs were sort of kept in, sort of kept out from the MiCA regulation, because the point of MiCA is basically to cover all crypto assets with one regulation, so nothing would be actually left out.
Yeah, completely correct. And I think the ultimate question there for the regulator will be to look at a hypothetical consumer of an NFT and think whether or not they actually care which one they get. If they care, it's very important to me aesthetically that it looks a certain way. It's a single unique piece of art, the Mona Lisa in an electronic form, then it shouldn't be regulated under MiCA. But if I don't really care which one of the 10,000 I get, then most likely I'm not buying it for the art value.
We have also a couple of questions. So the first question is actually another question, but I quote, not exactly a question, but thank God we do not have SEC in Estonia/Europe. So USA Securities and Exchange Commission.
Hear, hear.
But yeah, how it tests is actually kind of fair, but let that be. That's a securities law question. But another question is quite a long one. The question goes as follows. Under the legislation, not only must crypto companies keep the public informed about their pricing process and trading volumes in real time, but they must settle all trades the same day those trades happen. Exchanges must keep separate their own funds, including crypto and funds belonging to their clients. The regulation also explicitly prohibits insider trading. So, does this mean we can expect even more situations like FTX?
Good question. I would say we would probably see a lot fewer cases like FTX because the point of MiCA is to avoid those things through constant monitoring by the regulators, and also making it much harder to actually stay in the market if you're not complying with the own funds regulations and you're not complying with the reserve assets regulations, etc. So I think it would be much harder to operate analogous platforms and go bust in the same manner under MiCA. So I would say it's actually it reduces the chance.
Yeah, I agree because getting the license is so difficult, and the companies that get the license most probably have the required procedures and documentation and stuff already there. So the chances of like clients losing their funds or money and having such kind of circumstances would probably not be the case. And the last question.
Yeah.
What about digital twins? Representation of an asset in real life, document, car, agreement, product, shipment. Would they fall under MiCA?
Yes. Quite simple. It's the most basic example of an asset reference token. The fact that it's a single token referring to a single item or right doesn't in any way exclude it from MiCA. Now, so yeah, if I establish a business which is intended to create tokenized real estate or whatever, referring to the immovables register, then those things would, unless they fall under MiFID or something like that, then they wouldn't fall under MiCA. At least that's my understanding of it. Yeah.
Yeah, I would just add that the question is whether this token, the digital representation of something, involves any rights or obligations. That's the question. Yeah. If it does, then it most likely is an crypto asset under the new regulation.
Yeah. So, the final question from me to be answered, and then I will give the floor to Dan. Virtual currency, is it dead and gone? The reason why I'm asking that question is that under Estonian regulation, we're only specifically dealing with virtual currencies, or at least specifically Estonian regulation dealing with crypto is only dealing with virtual currencies. So the question is whether or not MiCA actually cares about virtual currency specifically, or is that something of the past? So Estonian license covers payment tokens. If, for instance, if you're selling in Estonia, if you have an exchange and you're selling tokens that don't fall under the definition of what a virtual currency is, it isn't a payment token, then the license doesn't actually have anything to do with you. And quickly, the definition of virtual currency is digitally represented value which is not legal tender in any country using the blockchain, essentially, which is accepted by third parties as a means of payment. So if it's not accepted by third parties as a means of payment, or if it's not transferable, then the Estonian regulation doesn't actually have anything specific to say about it. But MiCA doesn't care about that, which makes sense because the Estonian regulation was quite arbitrary in that sense. It doesn't really make sense to exclude tokens that aren't specifically meant for buying things. And that third parties don't accept as means of payments. So MiCA deals with all the crypto assets as the same, essentially, unless they're specifically defined in MiCA. So that has always been a gray area under the Estonian license, because you would oftentimes see Estonian license holding exchanges selling tokens that clearly are not payment tokens, that you're not supposed to be using for buying stuff. So the question was whether or not that is allowable. So under MiCA, that will be quite clear. And now I will give the floor to Dan-Erik, who will talk about new licenses and requirements for crypto asset service providers. Thank you.
Thank you, Rauno. So yes, let's move on to the specifics now. We covered what is out, and now let's move on to what is in. And firstly, MiCA, one of the most important parts of the regulation is the new license, and let's call it the MiCA license. And while there are other, to put it simply, there are other or many different types of licenses in the regulation, but the MiCA license for CASPs, which are crypto asset service providers, is one of the more substantial parts of the regulation. And as we covered, crypto assets are a wider definition have a wider definition than just virtual currencies. And so basically, if you deal with crypto assets in any form, then it's very likely that you will need the new MiCA license. This will include the current services that are already listed in the current AML Act of Estonia, the MLTFPA, or the Money Laundering and Terrorist Financing Prevention Act. But MiCA will also include new types of services that previously were not specifically regulated, or they were in a sort of gray area. But now MiCA regulates them, and if you provide those types of services, you will need a license. And I'll later specify which services these actually are. And the new license, of course, includes a new license application process or procedure, which will, in principle, be quite similar to the virtual currency license in Estonia. The application procedure will be quite similar, but as the MiCA will create a sort of legal certainty, at least for some time, then the process to apply for a license will also hopefully be more transparent. And of course, the license includes modified requirements for service providers. And I'll also go over some redundant the Estonian AML Act requirements that will no longer be imposed on the service providers. And of course, as Rauno mentioned earlier, passporting will now be allowed and regulated, which we believe is a great, let's call it a win. So the new license, or the MiCA license, as I said, it's one of the most important changes the new regulation brings, and it will be uniform in all member states, as all CASPs, crypto asset service providers, must apply for the same license with the same requirements, same obligations, same procedure, and so forth. The license is not substantially different, as if a service provider is currently providing exchange services, then the MiCA license still enables them to provide that same service, but it will include new types of services that also have their own special requirements in the regulation. And there's a catch. As I already mentioned, the MiCA license has to be applied for. There's no easy way out. A new separate application process will have to be followed. The relevant authority will assess the application and ultimately decide to either grant or refuse to grant the license. And there's no way to, at least in the current version of MiCA and to our understanding, there's no way to transfer or modify or to otherwise simplify the process to be granted actually the MiCA license. So if a service provider has a valid license, then they want to continue to provide the services they're currently providing, then they will need to apply for the MiCA license. And the new license also includes the new competent authority. Currently, it's the FIU who's dealing with virtual currency service providers. It will be to the best of our understanding, the FSA, so the Financial Supervision Authority of Estonia, which means that the applications will be submitted to the FSA, and the FSA will review the application, make the decision to grant the license, perform supervision, issue notices, request for further information, and if relevant grounds are identified, the FIU will be the one to withdraw the license. And the old...
One slide
sure.
perhaps, is that why this change is actually important, or why this change makes any change, is that the FIU has had the virtual currencies for a long time, and this is the only thing that they have made supervision of. The FSA, who is probably going to have the supervision, is the supervisory authority in Estonia who has been dealing with like the hardcore payment services, you know, securities, payment service providers, licenses, creditors, credit institutions. So like this is again one of the signs how the regulator will take crypto more seriously, because they are giving the supervisory authority title to the larger regulator who is dealing with those hardcore payment and financial service provisions.
Yeah, yes, thank you for that. So basically the crypto service providers will be treated with the same seriousness and let's even say respect as banks. And the old license, so the current license that was granted under the current AML Act of Estonia, we will probably start calling it the old license because it will expire once MiCA is implemented. And this means that the FIU will no longer be authorized to issue this license. The already issued licenses will cease to be valid. And the relevant crypto asset service providers can only be the relevant crypto asset services can only be provided with the new MiCA license.
I'll quickly add here that Thomas will probably give some insights into when this will presumably happen. So when will control be given over to the FSA, whether it will be given over to the FSA, and if it will be given over to the FSA, then when will the licenses become null and void, et cetera, et cetera. So all the practical stuff. And before we get to the next slide, Dan, we have a couple of questions for you. One, essentially, I think the two questions are quite similar. Basically, what they're asking is whether or not Estonia is a good place to do business in, specifically considering that the AML Act of Estonia, Article 31 of it, which deals with the onboarding of non-EEA clients, is quite prohibitive. As we all know, basically it's impossible to onboard non-EEA clients into an Estonian crypto company unless you meet them face to face. Basically, that's or they have an ADAS ID card. So, the question is, do you think that will be an issue moving forward with MiCA? And the other one basically asks the same thing. Do we see that countries will compete with each other for where it will be best to get the license in, considering also the fact that in Estonia currently it's hard to onboard non-EEA clients?
I believe that it's a bit gray at the moment because the onboarding of non-EEA clients essentially is a due diligence requirement, and MiCA does not touch that subject. MiCA touches the new license and the services which can be provided under that license, but it doesn't regulate what due diligence measures will need to be applied under that new license. Of course, MiCA, the current version of MiCA has several provisions that say certain organization will start drafting guidelines on how to specifically or how to better fulfill the requirements of MiCA that maybe aren't specific enough, and maybe moving forward it's possible that these guidelines will also create a more uniform requirements which inadvertently affect the requirements regarding due diligence, which I'd expect will be uniform across all member states, and it might affect non-EEA customer onboarding. And I don't believe that this will actually incentivize member states to start competing with each other on who gets to grant licenses and who gets to be the host member states, because the long game of EU is that everything is the same everywhere, at least in the member states. So member states, the different requirements in different member states will most likely not be that different that any member state will actually get some competitive edge.
Question from the public, but I'll also add to that. So since we have Thomas here also, he will be talking later. I'm sure he will have some insights to whether or not there is plans to change this Article 31. Maybe, maybe not. I would imagine that it would be changed, since I know there have already been talks about changing it, making it more generic. But I think there will definitely be competition among countries for who gets to host these licenses, just as there is competition for who gets the most payment service providers and banks, etc., where it's better to do so, etc. I think Estonia will be a good place to do it because the regulators have experience with crypto a lot more than others. But yeah, a question from the audience. There's a mic also.
Thank you. Since the license is passportable and it will valid throughout the EU, does it mean that if you apply to the FSA to get the new license and you're not granted it, it means that you have squandered your chances elsewhere as well?
Not to my knowledge, no. If you're... No.
Yeah.
No.
If you had the license and it's taken away, then there may be a problem of reputation in the other state. But if you apply for it and you don't get it, I wouldn't say that's a big problem, but of course it depends on the grounds why it was not granted.
Yeah.
Are there any restrictions in reapplying or going over the process again? If you, for instance, in a certain jurisdiction you don't get it, and you try maybe, since it's passportable, it won't really matter where you get it as long as you get it in the member state, right?
Yeah, if you get it in one member state, then you're good in other member states as well. But perhaps Tanne knows it, but I at the moment do not know it from the top of my head, whether there is like some kind of period after refusal of the license where you cannot apply for it again.
Yeah, well...
Yeah. The current version of MiCA, to my knowledge, doesn't mention this, and but I'll get on the specifics later. But under MiCA, passporting isn't as easy as getting your license granted and then just, for example, the Estonian authority grants you the license and then you can start providing services in Italy. There's also a small step or process that has to be followed to actually provide services cross-border, which in my opinion implies that since the host member state authority grants you the license or refuses to grant the license, and is the organization that assesses the service provider or the potential service provider, and then the other member state authorities have not done so, and ideally, they should be able to do it on their end, and there shouldn't be specific restrictions, to my knowledge.
Thank you.
Okay, moving on.
And so on to the more specifics, what are actually the services covered by the new MiCA license. There are the old and the new services. The old services are the main types of services that will remain mostly unchanged. The wallet service and the exchange service, for example. Although it is important to note that the definitions of these services are slightly different or worded slightly differently than in the current regulation, in the Estonian regulation. So each service provider must analyze the services separately and actually assess whether it falls under any of the new definitions. And this is important because MiCA also has new types of services that previously required no authorization, no license to be provided. And I'll just quickly list all the services that MiCA lists. So first is the custody and administration of crypto assets on behalf of third parties, the operation of a trading platform of crypto assets, the exchange of crypto assets for funds, the exchange of crypto assets for other crypto assets, the execution of orders for crypto assets on behalf of third parties, placing of crypto assets, then there's the reception and transmission of orders for crypto assets on behalf of third parties, and providing advice on crypto assets. And out of these services, it seems to be that the classical services covered by MiCA are the wallet service, which is the custody and the administration of crypto assets on behalf of third parties, and the exchange service, which is actually divided into several parts. It's the operation of a trading platform for crypto assets, which basically is creating the possibility to exchange crypto assets for users. And then there's the exchange of crypto assets for funds and the exchange of crypto assets for, the exchange of crypto assets for other crypto assets, which mean when the service provider performs the exchange transactions on their own behalf. And then the new types of services covered by MiCA are the execution of orders for crypto assets on behalf of third parties, which means the concluding of agreements to buy or to sell one or more crypto asset or to subscribe for one or more crypto assets on behalf of third parties. Then the reception and transmission of orders for crypto assets on behalf of third parties, which is the reception from a person of an order to buy or to sell one or more crypto assets or to subscribe for one or more crypto assets, and the transmission of that order to a third party for execution. And then there's the placing of crypto assets, which is marketing on behalf of or for the account of the offerer or of a party related to the offerer of crypto assets to purchases, which in easier terms is marketing a new crypto asset that's not traded on any platforms yet. And then there's providing advice on crypto assets, which is offering or giving or agreeing to give personalized recommendations to a third party, and the advice is in respect of one or more transactions relating to crypto assets. And each of these transactions, each of these services, both the classical services and the new services, have their own specific requirements in the MiCA, but also general requirements. And first I'll quickly go over what is the application procedure for the MiCA license.
Wait,
Yeah, sure.
There's a question, if you can bring back the last slide. So there was a question regarding the advice on crypto assets. So the question is, can we elaborate on it? Which you've done, and the question was whether a lawyer advising a client would count under there. So presumably I would say no, because a lawyer wouldn't be providing advice in respect of one or more transactions relating to crypto assets or the use of crypto asset services in the context of whether or not you should do it in a financial or economic sense. They might advise you on the question of how to do it and whether it's legal to do it, and how to structure the deal. But as long as the lawyer isn't giving you suggestions on which crypto to buy, which ones to sell, where to buy them from, then not really. Yeah.
The advice.
Henry.
I have one side note. It seems to me that the intent of the regulator, as you saw, so many services, so many terms, it is all very technical. The overall intent of the regulator is pretty much license every service that deals in some sort of way with crypto. So this is the intent. And this is why there are so many different types of services covering every possible angle.
Exactly. Yeah, I'd also like to add that the providing advice most likely includes portfolio management. So it's the idea of this service type is that if someone who doesn't know or who isn't enough of an expert or who trusts someone who should have more experience than them, or simply who are smarter than them in the crypto sphere, then that service provider should have a higher standard of requirements and liability, and this can partly be achieved by a license. And how to get the license is first the applicant must submit an application to the relevant authority. In Estonia's case, we believe it will most likely be the FSA. There are two assessments. First assessment is done by the relevant authority within 25 working days, and where they assess whether the application is complete or not, whether the applicant has submitted all documentation or not. If not, a deadline is given to the applicant, and once a complete application is received, then the relevant authority must, within 3 months, adopt a fully reasoned decision. And once the decision is adopted, then in 3 working days, the applicant will be informed of that decision. And the requirements for service providers, which some are new and some which are currently valid, will be redundant. The general requirements are, there are just a few examples, but the capital requirements, which are of course different for different service providers, the reception and transmission of orders, advice service, execution of orders, and placing crypto assets have the lowest requirement, 50,000. The wallet service has 125,000 capital requirement, and the highest requirement, 150, is for operation of a trading platform and exchange services. There are also prudential safeguards, which at all times must be equal to an amount of at least the higher of the amount of permanent minimum capital requirements, as listed above, which depend on the service provider. Then 1 quarter of the fixed overheads of the preceding year, which will be reviewed annually. And the safeguards shall take any combination of own funds or an insurance policy or some other comparable guarantee. And there's also some general requirements for safekeeping of clients' funds. The client's funds must also be placed with By funds, this does not include the crypto assets. This includes other funds which must be placed with the bank and in a separate account from where the service provider holds its accounts, its own funds. And there are also other, for example, government's requirements such as drafting, of course, policies, favorite thing of every crypto service provider. And for example, the business continuity, risk documentation, and outsourcing. And there's also service providers must draft a plan for orderly wind down should they stop providing their services or lose their license. And there's an obligation to act honestly, fairly, and professionally, and to be in the best interest of clients, and also some consumer protection requirements, such as transparency and publishing certain procedures that consumers should be interested of. And then there's the service-specific requirements, which for the wallet service, to name a few, wallet service providers must register each client's crypto assets, and they must provide to their clients periodic statements thereof, and they also have to segregate the crypto classes of crypto assets of clients from their own crypto assets. And MiCA specifically references different addresses in this context. Then operating a trading platform, there's an prohibition of dealing on the platform for crypto assets they operate, even if they are authorized to exchange crypto assets. And the exchange services must publish the details of the transactions concluded by them. The execution of orders from third parties those service providers must consider the best interest of their clients, which means that they, while every service provider must do it, then these service providers have a higher requirement of this. Placing of crypto assets have specific pre-contractual information requirements, and the reception and transmission of orders. In case of this service, the service provider must receive no remuneration, discount, or non-monetary benefit for routing clients' orders to any particular or specific trading platform or any other CASP. And the advice service has also transparency requirements for their advice, and they must understand the client's objectives, their experience, financial situation, and make a decision that is best for them. Some redundant requirements are the auditor requirements. There's no longer a specific requirement for virtual currency service providers or CASPs as a whole to audit their annual report. Therefore, they also don't have a requirement to have an external or an internal auditor. And the overall audit requirement pursuant to law will apply, which applies to all companies across Estonia. And for example, also the higher education requirement will disappear, which means that members of the management body of CASP only have to have a sufficiently good repute and possess knowledge, experience, and skills needed to perform their duties, but they don't have to have a higher education. And they also don't have to necessarily reside in the host member state. And we have a question from the audience.
Yeah, mic is coming up.
Yeah.
It will come.
Thank you. Can you go back a slide, please, and the service-specific requirements?
Mm-hmm.
The operating of a trading platform, the prohibition of dealing on the platform for crypto assets they already operate. So how are market makers gonna operate? How is market making done? Usually you contract a third party to do it for you, but it's your contract with the third party that operates on your own exchange for market making purposes, which guarantees the clients some benefits that they otherwise wouldn't have. So are those banned from MiCA?
I believe that there's an exception that allows service providers to do this if they have the client's consent, and but also this includes some further and more strict requirements, and their authority will have to do some additional supervision in this regard.
Okay, thank you.
There are some additional questions also online. So I'm going to paraphrase this a little bit. Essentially, it's a scenario question. A company currently has, let's say, has some issues with the FIU, has maybe in the past breached some of the Estonian AML Act requirements or some other requirements. Is it foreseeable that as a result of that, they will have an issue getting the MiCA license? Will the FSA take those things into consideration? Do we know that?
I don't think it's regulated, but realistically, it's going to affect.
It's a question of good reputation, because the MiCA regulation also says that the natural persons behind the company, including the management board members, must have a good reputation. So if the FIU has taken the license away, actually, this is a questionable whether the management board has good reputation or not.
The company itself as well.
Yeah, the company itself as well. Yeah.
And so there's another quite interesting question. Basically, it's asking if I provide development tools to create and deploy smart contracts, would it fall under MiCA requirement? In theory, it could be used to create any crypto assets. Could the tool be considered as a service providing advice in relation to crypto assets? Now, I would step in here and I would say that usually in our analysis, we will always said that if your service provision essentially only entails licensing of software, then it won't. Licensing of software does not fall under MiCA. However, usually there are additional services like SaaS or consultancy or running servers in the name of your clients, etc. So it usually gets more complicated than just providing development tools as code. So it needs to be analyzed what the actual service is there. Yeah.
Yeah, I agree. And I'll quickly go over some of the new possibilities, or one specific new possibility of MiCA, which is passporting, which we've gone over a few times. And in other words, it's the cross-border provision of crypto asset services, which is now allowed and regulated. But as I mentioned earlier, there is a certain process to do this. The service provider must notify the relevant authority, and MiCA lists certain information that has to be submitted to the authority of the host member state. And the authority will, within 10 working days, communicate that information to a single point of contact to the other member states where the service provider wants to start providing their services. So they have to pick member states. I believe you can also pick all member states, but this will, of course, make the process maybe a bit longer. And the CASP will be informed of said communication, and they may start providing their services once they have been informed, or latest 15 calendar days after they have submitted the first information that they intend to provide services across borders. So there's no specific authorization, there's just a notification process. And it's different from the current regulation. How? This is once the remote starts working, I'll tell you. The keyword is the new license, and the new license enables all CASPs to know that they can boldly and actively provide their services in basically any member state, provided that they have made the relevant notification to the competent authority and the timeline has passed. And I believe Henri wants to talk about the new rules for ICO, so I'll give the word to him.
Yes, the stick of magic. So ICOs, bunch of new rules. Let's go over them. So most probably I will not explain what an ICO is because the crowd most likely knows it, but it's issuing tokens, coins, whatever functions and rights they may have. And the first question how to understand what are the new rules for the ICOs is to understand what actual token is issued by the issuer. So it boils down to what the token actually is. So first of all, there are rules for any kind of crypto assets. So this boils down to the question of the crypto asset definition, as Rauno explained before. But basically, crypto assets are any technical tokens which carry on some kind of rights and obligations, but which are not asset reference tokens or e-money tokens. So for example, if I want to issue payment tokens which are not e-money tokens or utility tokens, for example, which give a right to consume the services that I provide as a company, so this will be under those rules. So the second batch of rules is for issuers of crypto assets which are assets reference tokens. So for example, the stable coins. If I want to issue stable coins, then I have to take a look at these rules. And the last batch of rules are are for issuers of crypto assets which are e-money tokens. So e-money regulation has been there for years now, but the MiCA basically gives a few more rules to tokens which are considered as e-money tokens. But very importantly, it is to understand that if you are going to issue security tokens, then these will not go under the MiCA regulation. These are still under the same old securities regulation. So the most important takeaway from this slide is that as the issuer of the tokens, the first task is to understand what the tokens are, so you know the rules that you have to follow. So let's start off with the first batch of rules, which are rules for issuers of the typical crypto assets, for example, utility tokens. Some general requirements. So basically, these new rules from the MiCA regulation, they cover offering of crypto assets to the public if I'm going to issue those crypto assets and I'm going to offer them to the public myself. Or they also apply when I, as an issuer, am seeking admission to the trading on a trading platform. For example, I want to find a trading platform that will basically give and provide these tokens to the public. Even in this case, I am covered with the rules of the MiCA regulation. Very important also, a general requirement is that issuer must be a legal person. So the good old story about decentralization and smart contracts is not going to cut it, because the first requirement is that the issuer must be a real legal person in the European Union. Also, one of the most important things is the obligation to draft a white paper. Basically, I guess every ICO has a white paper, but now the regulation actually says that you must have a white paper. You must also notify it to the competent authorities, and you must publish it. And most importantly, there are very specific requirements what the white paper must meet. This is kind of similar to the prospectus regulation, which deals with issuing securities, as the prospectus regulation also says that you must, if you are issuing securities, you must publish a prospectus which meets certain requirements. And the notification part, I will go into that in a bit, but in a nutshell, it means that I have to send the white paper to in Estonia to the FSA. They will take a look at it, but there is like no certain, they cannot say no to it, but we will get into it. And also a publication of the white paper, so I must publish it on my webpage, for example. So it's there and everybody knows about it. One of the most important aspects here is also that there is no authorization required for that. So you do not need a license for it. This is the main difference between the regular crypto assets versus the crypto assets, which are assets reference tokens and e-money tokens. So I mentioned that there are tons of requirements for the white paper, and indeed I was correct. Here is just some examples, and it's going to be a wall of text, but bear with me. There are requirements for a very detailed description of many things. For example, there must be information who is the issuer of the tokens, what the project is about, what are the milestones of the token issuance, the natural persons behind the project, who are the management board members, who are the councillors, and so on. Also, it must say, the white paper must say what type of crypto assets are offered, whether they are the regular crypto assets, whether they are the assets reference tokens, and so on. So the white paper must very clearly say what type of the crypto assets are offered. Also, regions for issuing. Why does the issuer want to issue the tokens? This yeah, you can put money. No, there must be real reasoning behind it. And also, the white paper must include a description of the funds, the funds that they get from the ICO, how they are going to use them. Are they going to use them for product development, services development, and so on? So this must be described. Also, number of crypto assets issued, issue price. These are typically in the white papers already for many ICOs. Very importantly, the white paper must also explain the rights and obligations which are actually attached to the tokens. So if I buy a token, I'm the purchaser. What do I get? What do I have to do? Do I get like an access for a service? And what are also the details of the rights and obligations attached to the crypto assets? For example, if I have 10 tokens, how much service can I buy, or how many goods can I buy? Can I buy one hat for 10 tokens, and so on? So these must be really described in a detailed way in the white paper. Also, utility tokens, even more specific details of the products and services which could be consumed with those tokens. And how the redemption process goes. Where do I have to go with my tokens to get the service/goods that I'm promised? And also technical stuff, information on of the technology behind it, and the protocols, the standards, the whole 9 yards. And the favorite part of the favorite part of every white paper: what are the risks which the purchaser takes? That you know the drill, that the tokens may lose their value and so on. But the regulation actually goes more deeper into that. These are just some examples of it. Also, some obligatory disclosures. For example, this also relates to the risks that the tokens may lose their value. They may be not transferable. They not be liquid, and for utility tokens also a disclosure that if the project fails, then there's nothing to do with the utility tokens actually. And from general part, as for the prospectus, there must be a summary which in a non-technical way explains what the token is, what does the white paper say, and so on. And like the general stuff that the white paper must be complete, fair, and not misleading, and so on. So very many requirements for the white paper. Yeah, we have a question from the public as well.
So a question regarding, you mentioned in the previous slide that once you create your white paper, you need to notify the regulating body. So does it mean that there will be like a EU-wide library of all the white papers available somewhere?
There will be, yeah. The body, or the authority body that you have to notify is the home member state body. So in Estonia, the FSA. But yeah, the white papers will be kept on the EU level in a dark storage room, some in the cellar of Brussel's office.
A couple of questions also from the online portal. The first one is quite interesting. They ask, a bit off topic, but what if I'm selling my personal car on Facebook using self-made and self-owned ERC 721 contract? Would I breach MiCA as a private person? So the answer to that is no, because you're not providing any service. Just as under current regulations, law firm LEXTAL could accept well, okay, a law firm is a bad example, but a company could accept Bitcoin in exchange for goods and services that they're providing, and it wouldn't be considered as virtual currency service provision because that's not the service. The service is something else. It's just accepting a means of payment. In this case, there's clearly no service provision going on as well. The second question actually goes to Dan and asks, does a single MiCA license cover all of the activities that you mentioned, or would a company need to apply for a new license for each activity they want to engage in?
The MiCA license will cover all the activities, but in the application process, the CASP must note down what services they're going to provide.
And the requirements will be quite different depending on which ones marked down.
The application requirements and also the service provision requirements will be different. And the more services you provide, the more requirements you will have to follow. But you can provide all these services under one license.
Yeah, just one more detail. When you need an authorization to issue asset reference tokens, which we'll discuss later on, this is a separate license. So this is not a crypto asset service provider's license, but this is license for issuing.
Yeah.
So that's a different one. But okay, let's move on. So tons of requirements for the white paper. So what if the white paper does not meet these requirements? Of course, the regulator will come and hunt you down, but in addition to that, you have to pay euros and dollars, as you can see from the photo on the right side of the slide. So basically, it means that the purchaser can come after you with a claim if the white paper does not meet the requirements, if the white paper is not clear enough in some parts. And we lost it. Okay, the TV came back. But the thing is that this kind of infringement of the requirements of the white paper must have had an impact on the decision for the purchaser to buy, for the seller to sell, or for the exchanger to exchange the crypto assets. So there must be some kind of like a cause to that as well. So, for example, if the white paper is very, very shady and I buy lots of it, or the white paper says that I can use that token to buy, I don't know, SaaS services, and I cannot, then I can go with a claim after the issuer. And very importantly, exclusions of civil liability are avoided. So you may write in the white paper that nobody has no claim against me, or we sell the tokens as is basis with no guarantees, but this will not hold up in a court. So these kind of liability exclusions are indeed void. So I also mentioned the notification to the authority. So basically how the process goes is that you will draft the white paper, you will follow all the requirements, it will be 200 pages long, very good read indeed. And then in order for me to actually issue those tokens, I have to send it to the FSA beforehand. So this must be done 20 working days before publication, and this also goes to the marketing communications as regards to the tokens. But however, very, very importantly, for these kind of crypto assets, and we're talking about crypto assets like the regular crypto assets, not the asset reference one or not the e-money tokens, the FSA will not green light it or red light the white paper. They will not say yes or no. You will just send it to them. That's it, 20 days beforehand. However, of course, the supervisory authority has a large number of powers from the MiCA. So basically, if they see that there is anything wrong with the white paper, they may suspend the project or abolish it altogether. But they will not green light or red light it that quickly. And also, very importantly, the notification that you will send to the FSA must include the explanation why these crypto assets that you are going to issue are not some kind of financial instruments. For example, that these tokens are not security tokens, they are not e-money, they are not some kind of deposit that you are holding, because for that you need a credit institution license, and so on. So basically, if you're going to issue utility tokens, you must give them a legal opinion that these tokens indeed are utility tokens, so they fall under the crypto asset regulation. And as I mentioned before, this, this I didn't mention before. So you will go and send that white paper to the FSA of your state, so where you are located, for example, in Estonia to the FSA. But this notification must include a list of the member states where you want to issue those tokens. So for example, if I want to actively promote those tokens in Germany, for example, then I have to list Germany as well into the notification that I will send to the Estonian authority.
I'll quickly add here. This is especially important considering the fact that as of now, at least in Estonia and many other European countries, issuance of utility tokens, quote unquote, which is the dream, right, has been largely unregulated, and you can just do it on a contractual basis, no administrative overhead. So this will change that.
Dramatically, yeah. Also, MiCA covers the publishing of the white paper and the changes to the white paper. So in a nutshell, the white paper must be published at the issuer's website from the starting day of the offer. Again, very similar to the prospectus regulation. And also, the white paper must be available at the website until the public holds the tokens. So this could be a very long time. And also important, it must be identical to the one that you sent to the regulator. And if you need to make modifications, then of course they must be done if you want to change something like dramatically. But then you have to inform the public and also let the authority know and send them the new white paper as well. Along with the reasons why you're changing it, of course. You cannot change it just because you want to change it. So what about exemptions? Do I have to publish the white paper all the time? So as we discussed, no authorization, no license needed for that kind of activity. But do I have to make the white paper in every case? In certain cases, no. Very specific cases, no. So for example, if the crypto assets are offered for free, I'm giving them out, but if I want to get the personal data, for example, or some kind of services from the purchaser of the tokens, then they are not free. So they must be actually free. In this case, you do not need the white paper. And if the crypto assets are unique and not fungible, this is the topic that we discussed before. Most likely for the typical NFT, I don't know, pictures of the apes, it's not the case. It does not fall under this exemption. Very similarly to the securities regulation, again, if you're going to offer these crypto assets to fewer than 150 persons, then you do not need the white paper. And if the purchaser's amount is if the offering is small, so basically over the period of 12 months, the offer does not exceed €1 million, then you also do not need the white paper. And again, similarly to the prospectus regulation and the securities regulation. If you're only going to offer them to qualified investors, then you do not need the white paper. For example, you're selling the tokens to, I don't know, banks and credit institutions. So these are the exceptions when you do not need the white paper. One more important topic as regards these crypto assets, right of withdrawal, the biggest fear of every ICO organizer. So for these kind of crypto assets, for example, utility tokens, the MiCA regulation introduces the right of withdrawal, which means that if a consumer purchases those tokens, so a natural person not acting in its economic or / professional life, then you must offer them a right to withdrawal. So basically they are going to give the tokens back and you will give them the money back. So this can be done over the 14 calendar days. So after I, as a natural person, as a consumer, buy those tokens, then I have 14 calendar days to say that I withdraw and I want to get my money or whatever currency I paid back. And this doesn't need any reasons. It's the same case if you purchase, I don't know, a sweater online. I can just send it back. It works the same way. And of course, you have to send the money back. Same means of payment typically. However, this kind of right of withdrawal only applies to the issuing of tokens. So if crypto asset is both in the trading environment, if the assets are already traded, then this does not apply. This only applies when the tokens are issued and I buy the tokens straight from the issuer, not from a trading platform in the course of trading. Because the rule wouldn't make sense because the value of the tokens fluctuates on the trading market, so I cannot withdraw in this case.
Makes sense to always first sell all the tokens to the platform and the platform then gets to sell them, not in an ICO, but...
Yeah, it's the question of environment. If they are freely tradable at the platform, then it doesn't apply. But if the platform is acting as the issuer itself, selling new tokens, not with the fluctuated prices, then it doesn't apply. Yeah, one question from the audience. Microphone, please.
So am I to understand that from the moment that the MiCA is valid on, the lockup investing periods before the token is effectively tradable will not be valid anymore because you have these 14 calendar days to withdraw? Or after these 14 calendar days, you can apply a lockup and vesting period?
You can apply the lockup period, but the thing is that during the lockup period most likely will be longer than the 14 days typically. But I can, in this case, withdraw during the lockup period within 14 days by giving the tokens back to the issuer.
If it's technically possible. If it's not technically possible, then you can't.
14 calendar days from the moment that I make the purchase. After that, then they can be locked up.
Well, technically, if you could structure it in a way where you lock them up with the option of unlocking them after 14 days, then it could still work, right?
I see.
But if it's not possible, then yeah, I would rather wait for 14 days.
Perfect. Thank you.
All right. Moving on. So these were the requirements and rules for the typical crypto assets, issuing the typical crypto assets, utility tokens and so on. So now we are going to briefly talk about the rules for issuers of asset reference tokens, which are different type of tokens. For example, these stable coins. So these rules are more strict in a very short way of saying. Again, this covers the same stuff. Issuing the tokens myself as the issuer or seeking the admission of the tokens to a trading platform. For this case, you do need a special authorization. So you need the authorization for this type of service or issuing specifically, or you need license of the bank, which is more hard to get. There are some certain exemptions also. For example, if the money involved is not too big, again, so 5 million euros over the 12 months of the outstanding amount of the tokens, I do not also need the authorization if I'm only issuing these tokens which are addressed to qualified investors, and only qualified investors can hold them. So these are the two exceptions. And of course, similarly to the typical crypto assets, for the assets reference tokens, I also need to draft a white paper which meets certain requirements. In a nutshell, these are the same requirements, but there are some more because assets reference tokens are, the rules for assets reference tokens are a bit more strict. Again, I need to notify the white paper to the competent authority, and I need to publish the white paper as well. So getting the authorization, there are, similarly to the CASP authorization, very strict requirements. Much documentation is needed. Just some examples. You need to, in order to get the authorization from the FSA, you need to submit the business model. You need the legal opinion, again, that the asset reference tokens are not indeed financial instruments, for example, that they are not security tokens to get that license from the regulator. Proof of good reputation, and also you need to submit the white paper to the regulator, which has the same requirements, but some more. Will not get into detail with them. There are quite many, and you need a lot of paperwork. You know, continuity policy, internal control and risk management policy, security procedures, and so on. So quite heavy paperwork involved with that. And how it works, so before, of course, you are going to issue those asset reference tokens, you need to submit the application to get the authorization to the authority. In Estonia, it will be the FSA most probably then. Then the authority will take a look of the documentation and white paper that you send to them. And within 20 days, they will say whether they think it's complete or there's a document missing. If there's a document missing, they will give you an extra deadline. After that, it's the second assessment by the authority. So within 3 months, the authority, for example, the FSA, will give a reasoned draft decision whether they want to give you the license or not. This is not the final decision, this is a draft. They will basically send it to you, and most importantly, they will also send it up to the Brussels as well. So basically, EBA, ESMA, and ECB, the European Central Bank, will take a look at the documentation, the license application documentation, as well as the already made draft decision by the local authority. And then the guys in Brussels will have a say what they think of the project. And of course, the applicant may provide some observations to this procedure as well. And then the guys in the EU will give a non-binding decision and opinion of the project to the local supervisory authority. And then the local supervisory authority will say whether they will give the license to the issuer or not. As you may probably see, I would say that the guys in the EU on the high level most likely have a non-binding opinion, but most likely they will have the final say. So this is quite complicated. But again, I'm talking about crypto, I'm talking about asset reference tokens, not the typical crypto assets. So again, quite similar stuff as regards to the publishing and changes. So once you get the license, you will publish the white paper no later than the starting day of the offer at your web page. You have to keep the white paper public, and it must be the identical one that you sent to the authority, and which was indeed this time green lighted by the authority by giving the issuer the license. And again, modifications are allowed and actually required, but this needs to be green lighted by the authority. and a few additional requirements as well. Again, I'm going to outline the most important ones because there are many. There is an obligation to have reserve assets because basically you are issuing stablecoin, which must maintain some kind of value. So you have some assets in your bank account or like another authorized CASP, which actually holds these assets for which you have issued the token. You must basically exchange the token very quickly if somebody wants to make it to redeem it against the money or the crypto. You may invest these reserve assets, but only to a very low risk asset classes, and you have to have very clear policy on how these tokens are actually redeemed. Here is also auditing requirements of regular and independent audit against the company and against the reserve assets as well. And there is also ongoing information obligation. So you have to, on an ongoing basis at your website, basically publish and disclose information, how many tokens are there in circulation, and what is the situation with the reserve assets. And good old own funds requirement is here as well. As I'm running out of time, very quickly on the e-money tokens as well. Some questions or?
There's a very short question. Can the white paper be in English or must it be in English?
That's a very good question. I remember reading about it. If I'm not mistaken, the regulation said that the white paper must be in one of the official languages of EU. But if it's common in that sector, it can be also like another language. So perhaps English is allowed. I would like to say it is, but I will not bet my head on it at the moment. So e-money tokens, very quickly. So just a short intro. E-money has been there for years. MiCA just states some few more requirements about e-money tokens, which is e-money but in a token form, basically. Again, issuing is subject to an authorization. In this case, it is also, again, the credit institution or the e-money institution. And the requirements for the e-money institution are in the e-money directive and in Estonia, the payment institution / e-money institution law as well. And the same requirements apply. And again, few exemptions, you do not need the authorization if you are only issuing those e-money tokens to qualified investors, or if the money involved is not too big. For this case, it's a 5 million euros of outstanding amounts against the e-money. And for this case as well, obligation to draft the white paper, notify to the authority, and publish it on your web page. For the white paper, similar requirements as discussed before, again, must be notified to the competent authority at least 20 days, working days before publications. Modifications are allowed and required. Again, quite the same story. And again, if the white paper is missing something or it is not clear enough, if it doesn't meet the requirements, then the owners of the tokens may come after the issuer, and the exclusions of civil liability are void. So nothing to do there. So I believe it's time to give Thomas the stage. Thomas will talk about, from the Ministry of Finance perspective, how the MiCA is actually going to be implemented in Estonia, and he's pretty much the one guy with his team who are responsible for implementing the MiCA in Estonia and basically creating those laws in Estonia so the MiCA can be smoothly taken over into Estonia's legislation. So I will give the virtual floor to him.
Well, I hope you can hear me. At first, I want to thank the previous speakers, such a comprehensive overview, and to pointing out several practical issues. And I believe I can agree most of those points. As said, my presentation will mainly cover how we're gonna implement the MiCA or MiCA regulation in Estonia. Just to general overview, or just general note, Ministry of Finance of Estonia is responsible for preparing different kind of financial services regulation in Estonia, and I'm the member in a small team in ministry which have been working to develop a special law to transpose MiCA or MiCA regulation in Estonia. To start my presentation, I hope you can see my slide. I think I'm trying to move to the next slide. At first, maybe it's useful to give you kind of general background, what is currently in force already, and in addition, what will come in addition to MiCA regulation in Europe. But I'm not going to speak about so deeply, just briefly trying to cover this. In left side in my slide, you can see what we have already in place is AMLD regulation. And I'm not going to speak about very deeply, but what is, I think, first of mentioning is that last year, actually, a special TLT regime was adopted and published in Europe. But this TLT pilot regime, meaning distributed ledger technology regulation, is mainly addressed to regulated markets, meaning that they can use this kind of technology for register different kind of securities. So it's not so much related with crypto asset service providers, but still we changed also our Securities Market Act in the end of last year and added a new term in our Securities Market Act, and we add a specific provision in Securities Market Act, and it says that you can issue securities in Estonia also by using some kind of distributed ledger technology. So it's the first time I think in Estonian legislation where we are mentioning such kind of technology. But in right side in this slide, you can see what will come in future. I'm on the next slides. I'm going to speak more detailed the national law of implementing MiCA, but in here I think it's important to stress that there is more to come, and there are also additional regulations which will have an impact to crypto asset service providers also in Estonia. In here you can see that new AML package is under negotiations at the European level. It consists of different pieces. One piece, a new transfer of funds regulation, according to my knowledge, is already agreed between member states, and it will be published, I think, in May. But other pieces of this new AML package I mean directive and new regulation are still under negotiations, and according to my knowledge, they will be adopted and published most likely in the second half of this year. But what is already published in Europe is a new act dealing with mainly cyber attacks and cyber crime. Official name of this act is Digital Operational Resilience Act. It was published in Europe in the end of last year, and it will be come into force in the beginning of 2029. And it will definitely have an impact to crypto asset service providers, as those service providers have also to make some preparations to be in line with this act. In simple words, the act is saying that different kind of service providers, banks, investment firms, and CASPs also have to be prepared to avoid different type of cyber attacks. They have some, for example, some testing obligations and so on, but I'm not going to speak about more, as it's quite a complicated issue. So I move on with the main issue, what we have on the table today. So in this slide, you can see the timetable of implementation, the MiCA regulation at the European level. The first point in here is saying that most likely the MiCA regulation will be published in official journal in Europe in May. I think it's rather in the end of May, and it's meaning that this regulation will be in force after 20 days of its publication, meaning in middle of June somewhere. But for the moment, this act is still under examination of lawyers and linguists, as this MiCA regulation is directly applicable in all member states, meaning that the translations of those of this MiCA regulation should be also quite solid. For example, we are a bit struggling with different terms, how to translate, for example, wallet in Estonian language or token. So it takes some kind of additional work to do. Well, but if it will come into force in middle of July, then it takes about 1 year when it will be applied to those bigger players, as we already heard before. I mean, by big players, asset referent tokens issuers and e-money tokens issuers. And according to my knowledge, I think in Estonia, we do not have such kind of players right now. Maybe I'm mistaken, but still, it doesn't mean that we should not be ready for hosting such kind of issuers also in Estonia. So if our FSA will be the competent authority under the MiCA regulation, then FSA will be ready in the middle of next year to take in the application of those asset referent tokens and e-money tokens issuers in Estonia. But I think which is more practical in Estonia is a point 3 in here. This concerns mainly the crypto asset service providers, which are basically virtual asset service providers now in Estonia. So for those providers, the MiCA regulation will apply in the end of next year. I think the relevant month is in November, meaning that starting with this date, so service providers can start to apply for authorization from the competent authority of MiCA regulation. And the last point in here, providing some grace period to those service providers who are already operating, who offering some type of crypto asset service. There is a member state option to provide extra time to not to, which means that they do not have to apply for authorization at the first place. They have some extra time, but the maximum date when they should get the authorization under the MiCA regulation is 2026, most likely in June. But there is a member state option that member state can reduce this period or not to allow this period at all. I'm going to cover this issue more deeply on my next slides. So I'm moving on. In here, you can see the main substance of the law, what we are preparing right now. I believe at least maybe some of you are aware that actually we started to develop a special law on crypto assets and also crowdfunding assets several years ago. I think it was already before MiCA regulation was published, but due to the different reasons, we have abolished or put this draft act on the hold. But the new draft act, what we are preparing for, is in several points based on the previous one, which have gone through different consultation rounds. But to be more precise, the new law, what we are preparing right now, I think there are 9 most important points what we are trying to cover. The first one, what have been already mentioned several times on the previous presentations, is that according to MiCA regulation, a member state should designate a competent authority. Also, it provides an opportunity to designate different competent authorities. But in the case of Estonia, most likely, or I think it's frank to say that it's going to be Estonian Financial Supervision Authority who will who will conduct the supervision under the MiCA regulation in Estonia. But in this draft law, we will stipulate more detailed way. And regarding the big players, if, for example, some asset referent tokens issuer or e-money tokens issuer are going above some kind of thresholds, for example, if I remember correctly, if the number of the holders of tokens are more than 10 million persons, then the competent authority will be European Banking Authority. So for those such a big players, there is a different competent authority in future. But according to my knowledge, we for the moment we don't have such kind of issuers in Estonia. So maybe it doesn't have such a practical impact for us for the moment. Secondly, the second point in here is regarding authorization, which was already covered in the previous presentation. The MiCA will stipulate in a very detailed way the documentation, the timeline, and the powers of the competent authorities. So actually, we do not see in our national law any of those provisions. However, there is an option that member state may apply kind of simplified procedure. In this sense, we haven't made any decision, but most likely we are not going to use this option, as I think what is important to understand that for the moment, FIU, which is the main body for supervision for virtual asset service providers in Estonia, is a totally different institution compared to FSA, or I mean, both of those institutions in Estonia are separate bodies. They have separate financing scheme. They are totally independent for each other. So in this sense, as our FSA will start to build the supervision from scratch, it's hard to actually to see some kind of simplified procedures. I mean, there is actually hard to see that applicants should not submit some kind of documentation, but still there are some maybe provisions which we are considering if possible. The third point in here is regarding the money. Supervision is not for free. As I mentioned before, our FSA is totally independent and it is not financed by the state budget. So there will be a separate supervisor fees to get the license for the moment. So licensing fees in the current law are quite low. For example, if you want to get a banking license, you must pay 1,500 euros. For other financial services bodies, it's lower. It's 1,000 euros. Most likely, those levels will be increased, but I think not drastically. But it will be not increased only for crypto asset service providers, but also for other financial service providers. Actually, those levels, I think they have been already placed since 2005. And if you compare those levies or those fees with other member states, those fees are rather low compared to other member states. And I think what is more important in here is ongoing supervisory fee, which have to be paid to FSA in every year. And the law will foresee methodology in this respect, but not exact number what will be the sum you have to pay every year, but it will foresee a ceiling that to ensure that different service providers will not pay not too much compared to the size of their business. To move on, the point 4 in here, regarding audit, it was already mentioned in previous presentation already. MiCA will provide some basic provisions for audit, but there is an option for member state to stipulate more detailed provisions. At first, there is a choice if we foresee kind of softer version of audit, it's review. We haven't made a final decision in this respect. This is under discussion, and also what we will going to stipulate in draft law is how auditors will inform FSA. So point 5 in here regarding the tool set of FSA, as MiCA regulation is saying that member state should provide the options and different tools for FSAs or competent authorities, how they can take different steps to avoid any violations, or to how to protect investors. It's a major goal in the nature of MiCA. So in this sense, we will stipulate pretty similar tool set in our national law compared to other financial services laws which are already enforced in Estonia. So, for example, our FSA can issue a receipt to get some information or make on-site inspections and so on. And if FSA before if FSA wanna take it further, FSA can also apply kind of non-compliance levy in Estonian languages, sunniraha. The point 6 in here, it's mainly related with the company law, as MiCA do not touch this issue very much. We most likely stipulate some rules regarding restructuring of company. For example, in Estonian case, is it possible to restructure company from the form of aktsiaselts to osaühing or vice versa? Is it allowed or not? This is under consideration. Or if there is a possibility that two different crypto asset service providers can merge, most likely they can, but there is a need of approval by FSA, and also there could be some kind of special insolvency regime for the crypto asset service providers. But again, it is going to be very similar to other financial service providers. The main intention is to protect investors' money also in this case. So point 7 in here, I think maybe it's not so relevant for Estonian service providers. It is mainly related with third country issuers and those service providers who have been licensed in some kind of in some third country. Actually, what MiCA or MiCA is saying for those service providers is that they need also a license according to MiCA, but there is a rule, a special rule, which is called reverse solicitation, meaning that if, for example, a client in Estonia, its own initiative is seeking for some kind of token himself or herself, for example, in US, then there is no need to establish a permanent presence in Europe for those kind of service providers. But still, in our national law, what we are planning to foresee is that if Estonian CASP is planning to provide its services in third countries, then there will be most likely some kind of information passing requirements, meaning that those CASPs should pass information of those kind of clients to our FSA. So point 8 in here regarding sanctions. Actually, quite recently, the previous parliament passed a law which will provide to our FSA a possibility to stipulate more higher sum of fines. They can fine different subjects according to the new law up to 5 million euros. It will be also the case of CASPs, but I think what is important to stress that this will be kind of the last measure, meaning that it's more kind of to discourage service providers not to violate the law. It doesn't mean that in any case our FSA wanna make a fine at first place. Just it's a possibility to consider. And the last point in here regarding the FIU licenses, the meaning in here is that if the FSA will be the new body for issuing such licenses, the previous licenses will be revoked, and in this sense we will have to change the AML law. But I'm going to cover this point also one of my next slides. So basically, this is the main context of national implementation law. But to move on, maybe. All right, I think this is this is the last slide of mine, and it touches the national timetable of the law in Estonia. As I already said, we are preparing the draft law right now, and the first point in here is saying that we will publish the draft law, I think, most likely in June in this year. Then we're gonna have the first consultation round, and we hope to get as much as feedback as possible. Then in the fall, we will have a second consultation round, and I think in the end of this year, we will be able to submit the draft law to the government, and the new parliament will most likely adopt the law in the beginning of next year, and then the new law will be in force. And as stated before, CASPs are most likely able to submit MiCA licenses to FSA in November next year. There is also a possibility to start consultations with our FSA before this date, and this may make it easier to understand what kind of requirements in practical sense are for applying a license and getting authorized by FSA. And the last point in here is most likely in 2025 the licenses issued by the FIU will be repealed but the concrete date is not decided yet. We will have to discuss this with our FIU and also with FSA. So this is not decided yet. I think from my side, it's all for the moment. I believe there are many, maybe as I mentioned in several times, that we have not decided or made any final decisions regarding several points. So I think it will be much more clear if we published our draft law in June, and you can take a deeper look and give us a feedback. And of course, we are open to discuss those issues regarding to national implementation law also in future. So I think for the moment, it's all from my side.
So, first of all, let me say thank you, Thomas, for joining us. It's been a pleasure getting the view of the regulator in terms of what's actually going to happen. We are quite pressed for time. We've had so much fun here talking that we've wasted all of our precious time. But before I wrap things up, I did want to ask one question from you, Thomas. And the question is quite simple, and I think it's the main question that everybody in the market right now has. And that question is, when it finally comes time to switch the licenses, the FIU license for the FSA license, is it going to be easy or is it going to be hard? And is it going to be useful to have the FIU license and then get the FSA license, or will the FSA be like, we don't care what happened before, we're doing our own thing and take it from scratch?
Yeah, I think it's a pretty practical question, but unfortunately, I think I do not have any final answer in this respect. But what I can say is that according to MiCA regulation, different supervision authorities and especially financial supervision authority should make a cooperation with FIU if CASP are in a process of applying authorization. And I think in some cases it might be useful that CASP have already got authorization by our FIU, and our FIU can pass the relevant information to our FSA. And in some sense, I think it's easier for also to our FSA to evaluate the background of this applicant. But in the end, it's hard to say, does it make it harder or easier?
Okay, understood. Again, a big thank you, Thomas, for coming and sharing your thoughts. Also, a big thank you to Henri and Dan, and me also. Once again, happy International Women's Day, and I hope you have a pleasant evening. This is it from our side, and bye-bye.